So welcome, everyone, to meeting number 44 of the House of Commons Standing Committee on Public Safety and National Security. We will start by acknowledging that we are meeting on the traditional unceded territory of the Algonquin people. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. Pursuant to the order of reference of Thursday, June 23rd, 2022, the committee resumes consideration of Bill C-21, an act to amend certain acts and to make certain consequential amendments, firearms. Today we have two panels. We'll start with the first one, of course. In the first hour, we have with us by video conference, we have Megan Hennigan, spokesperson for Families of Dawson. And in person in the room today, we have Polly Se Souvient, Heidi Rathjen, coordinator, and Natalie Provo, spokesperson. So we will ask each group to present a statement, opening statement of up to 5 minutes, and we will start with...
Appel au règlement, Monsieur le Président. Je suis désolée.
Call to order, Mr. Chair. Can you please confirm that the sound tests did indeed take place? Could you please confirm that sound tests did in fact take place on a call of order? Can you please confirm that sound tests did in fact take place for the witnesses online? Once again? Okay. Could you please confirm that sound tests were in fact carried out for our witnesses online?
Good intervention. So the clerk assures me that yes, it is so.
Merci beaucoup.
And I certainly thank phones. It is critically important for the interpreters. So thank you all. So we will start with, I'm getting the English translation here. That's okay, don't worry about it.
Yeah, it should be all right.
All right. Anyway, we will start. I will invite Ms. Rathjen and Ms. Provo to make an opening statement. Please go ahead. 5 minutes, please.
Provo, porte-parole de Police Se Souvient, mais aussi blessé lors du...
Hello, I am going to speak here with my classmate Heidi Rathjen, who's the coordinator of Police Se Souvient, as was mentioned earlier. Today we are here with Serge Tastano, the brother of Annie, who represents all of the victim families, Stéphane Bouillon, who is a survivor of the Polytechnique, and Hélène Thibault, who are also graduates of the Polytechnique, and William Sylvie Gagnon of the Confédération pour le rayonnement des étudiants jeunes du Québec and the student movement Taïsi. Today, we will concentrate on the means that can be used to enhance Bill C-21. We think that that is where we can make the most contributions. Certain elements will be discussed today, and these are requests that we have been making for almost 33 years now, so from the time of the shooting. We know that the problem of firearm violence is complicated. We also know that causes of violence are varied and vast. But one thing is sure, the combination of bad intentions and the ability to access firearms increases the chances of serious injuries and death. And this is at the heart of our efforts. We want there to be rigorous regulation of firearms because it multiplies the risks for violence. We want to reduce the risk of firearms falling in the wrong hands. I was faced with a shooter with a very strong firearm. The Polytechnique shooter, as well as other shooters, were legal holders of their firearms. No ordinary citizen should be able to legally possess a firearm that allows them to end several people's lives in a few seconds with simply pulling the trigger. It is for this reason that we and most Canadians would like to ban handguns and assault weapons without forgetting high-capacity magazines. It's for the safety of our citizens and our children. This bill is critical for us after 33 years. And seeing that violence is on the rise, we think that we're at the last minute. We need to act now, and you are able to do so.
I'm just going to focus on some of the key amendments that we are hoping to convince the committee to adopt. First of all, The first amendment that we are eagerly awaiting is one that was promised by Minister Mendicino on the day this bill was tabled, that is to introduce a comprehensive ban on assault weapons, including those that were not captured by the May 2020 Orders in Council. Secondly, in terms of domestic violence, remove sections 4 to 12 that introduce American-style red flag measures that is not needed, relevant, or helpful in the Canadian context. Third, strengthen the wording of Section 36 of the bill instructing chief firearms officers to refuse or revoke a license when they determine that an individual has been involved in domestic violence or stalking. It should not be up to one person to subjectively determine whether or not such an occurrence has taken place, as the definition varies, and also as some provincial firearms officers have been literally appointed to protect gun owners' rights. 4, amend Section 36 of the bill to exclude employment as a justification for exempting an individual from license revocation linked to a protection order. 5, include an expansive definition of domestic violence that includes all intimate and family violence, including non-physical forms like coercive control and threats of suicide. Regarding handguns, limit the current blanket exemptions from the handgun freeze for businesses in order to exclude gun clubs and gun ranges, and only exempt retailers that provide handguns to police or security firms, and only for those specific handguns. 7, restrict the exemption for Olympic shooting disciplines to those that are currently on the program of the Olympics. And failing to provide other legislative solutions, limit the exemptions to coaches and athletes that currently compete, train, or coach in handgun shooting Olympic disciplines, instead of the blanket exemption for any and all future beginners. In addition, the exemption should only apply to handguns that are used in Olympic disciplines. We would obviously strongly oppose any expansion of the exemption beyond the Olympic exemption. 8, amend the bill to ensure continuous eligibility for the Olympic exemption, not a lifetime exemption as it is written now, by requiring an annual letter to the chief firearms officers. This principle of continuous eligibility should also apply to the legal qualification to own a restricted weapon. Magazines, do not neglect the issue of large capacity magazines. The government has promised regulations to ban magazines that can be converted to their full illegal capacity, as have done a number of mass shooters. This is a good thing. However, there are many other exemptions and loopholes that also need to be eliminated. And finally, we hope this committee will push for rapid drafting of regulations alongside the bill. Experience has taught us that regulations could make or break a measure. Providing draft regulations in a timely manner is a way to be transparent on how these measures will look once implemented. It took 4 years to enact regulations after the tabling of Bill C-71. This is scandalous and should not be repeated. Thank you.
Thank you. We go now to Ms. Hennigan. Please go ahead. 5 minutes, please.
Hello to the chair and to the committee members. 16 years ago, I was shot in the arm and the lower extremity during the Dawson College shooting. I was one of 19 people who were shot. Anastasia de Souza, who was shot 12 times at close range, died. She was 18 years old. The shooter was a young man obsessed with guns. He posted at least 55 photos of himself posing with knives and rifles on his website. He frequented shooting clubs and ranges, including the same club where the 1992 Concordia mass shooter trained. He trained in dress combat boots and dark trench coat. The club administrators never raised any flags. In fact, he was able to buy guns from 2 Montreal clubs. He tried to join the Canadian Armed Forces, but he never got through basic training. He should have never owned a gun, and yet our laws allowed him to own 2 handguns and assault weapons. This means 2 things. First, our screening system is flawed. We need more thorough background checks, and we need authorities to prioritize public safety. Second, it means that until we have a perfect system, it won't be possible to prevent all at-risk individuals from access to guns because police can't read people's minds. And that's why some weapons are just too dangerous for private ownership. That's also why my family, Anastasia D'Souza's family, and other survivors like Haider Kadim have been calling for tougher gun control laws, including a ban on handguns and assault weapons. I was shot with a Beretta CX-4 Storm. This gun, like many others, should have been prohibited. The coroner who investigated the shooting said that the spirit of the 1995 law had been respected. It would have been banned.
Pardon me,
Need a
can I just interrupt you for a minute? The
Yes, ma'am.
translation in French isn't high enough. Could we
Et
test that?
aussi le volume, on a du misère à entendre le témoin.
Sorry, I didn't understand that because I passed.
Pardon, it's that the volume of the witness is not high enough. Please increase the volume of the witness.
Let's suspend for just a minute. Apologies.
All right. Thank you, Mr. Chair.
Hannigan, start from the beginning again, please, if you
From the
wouldn't mind.
beginning? All right. No problem. Okay. Hello to the chair and committee members again. 16 years ago, I was shot at Dawson College in the arm and the lower extremity. I was one of 19 people shot. Anastasia D'Souza, who was shot 12 times at close range, died. She was 18 years old. The shooter was a young man obsessed with guns. He posted at least 55 photos of him posing with knives and rifles on his website. He frequented shooting clubs and ranges, including the club where the 1992 Concordia mass shooter trained. He trained dressed in combat boots and a dark trench coat, and the club administrators never raised any flags. In fact, he bought guns from at least 2 Montreal clubs. He tried to join the Canadian Armed Forces, but he never got through basic training. He should never have owned guns, and yet our laws allowed him to own handguns and assault weapons. This means 2 things. First, our screening system is flawed. We need more thorough background checks, and we need authorities to prioritize public safety. Second, it means that until we have a perfect system, it won't be possible to prevent all at-risk individuals from having access to guns because police can't read people's minds. And that's why some weapons are just too dangerous for private ownership. That's also why my family, Anastasia D'Souza's family, and other survivors like Haider Kadim have been calling for tougher gun control laws, including ban on handguns and assault weapons. I was shot with a Beretta CX-4 Storm. This gun, like many others, should have been prohibited. The coroner who investigated the shooting said that had the spirit of the 1995 law been respected, it would have been banned. We need a comprehensive ban on assault weapons, and we need them to be taken out of circulation. We're looking forward to the promised amendment to ban all assault weapons and to the launch of the mandatory buyback program. The killer also used a .45 caliber handgun. Like 70% of Canadians, we support a ban on handguns. The freeze on new purchases is a step in the right direction, and we do support this measure. However, exemptions go too far. For example, why exempt gun clubs and ranges? Why should they be allowed to purchase new handguns? And why should we be perpetuating the so-called sports shooting that uses handguns? Why teach people how to shoot weapons that are easily concealable and can kill anyone in your vicinity by squeezing your finger? 25 years ago, a legal handgun odor killed 15 elementary school children and a teacher in Dunblane, Scotland. The tragedy prompted a popular movement that led to the ban on private ownership of handguns in Great Britain. Just 2 days ago, the families of the victims called on their government to ban these so-called practical or tactical shooting games. Though they use long guns, the ones here in Canada are using handguns. I agree with these families. The clubs are trivializing the use of dangerous weapons. These types of clubs glamorize shooting and weapons. It's an Americanized sport, and it's everything we want to get away from Canada and the UK. So we would really be pleased if the bill was amended to make sure that the handgun freeze applies to gun clubs as well. Finally, we're looking forward to the promised regulations to ban on modifiable magazines, which can be restored to their full illegal capacity. However, it's important to not forget to fix other flaws in rules surrounding magazines. For example, the Beretta CX4 Storm, even though it was restricted, was a long gun, and its magazine would normally be limited to 5 bullets. However, a loophole in the regulations say that if a magazine is not purposely designed for a specific gun in which it fits, it's exempt from the 510 limits. This loophole was blamed by the coroner during the Dawson investigation for allowing the gunmen to use 10-round magazines instead of 5 rounds. Police se souvient has been fighting for these measures since I've been alive. I'm 34 years old. I've been fighting for these measures for my entire adult life. My mother fought beside me for 15 years. She passed away last March without ever seeing the fruits of her labor. The coroner in the Dawson case said without 10 rounds, the killer may have only shot half as many people on the sidewalk before entering the school. I was shot on the sidewalk. My mother was standing next to me. Thank you.
Thank you. We'll start with our round of questions now with Mr. Shipley. Mr. Shipley, please go ahead, 6 minutes.
Thank you, Chair, and thank you to the witnesses for being here today. Obviously, many of you have been through very tragic incidents in the past, and our heart goes out to you as you try to carry on with your day-to-day lives. So my first question today is for, I think, Ms. Rathjen and Ms. Provo, please. Your organization's brief on Bill 21, you state that you, along with other major women's organizations, oppose the ex parte red flag measures, which invite victims to go to court themselves to have firearms removed from their abusers. Can you please explain why you oppose this measure?
Question. First of all, there's not one women's group that asked for this measure. And second of all, it's not relevant in the Canadian context, because in the Canadian context, women victims of abuse can call the police, and it's up to the police to come and investigate, and they have all the legislative tools necessary to remove the weapons if they deem that there's a risk. And the problem now that we've seen in too many cases is that often the police doesn't take complaints seriously and doesn't do their due diligence and prioritize public safety. That needs to be improved. There are some important measures in the bill that do protect victims of domestic violence, but this measure is dangerous in the sense that it could encourage, it could allow police to offload their responsibility onto victims. And I hope that women's groups will have a chance to testify, and they will be able to explain how expecting victims to go to court is unrealistic, and that may be relevant in the American context because they have the right to own guns, and there's room for going to court to remove weapons from dangerous individuals, but that's not the case here in Canada.
Thank you for that answer. Would you propose anything you'd like to see instead if we had to amend this, or just would you like it removed?
Removed? We have a number of amendments that we feel would improve the situation. Some are just tightening up measures that are in the bill. But for example, we propose an amendment to the language of the section where the chief firearms officers evaluates whether or not it's in the public interest to grant a license. That could be strengthened because right now the chief firearms officer needs to consider a list of factors but can decide either way. And there's been too many cases where, despite knowing about suicidal behavior or domestic abuse, or even police officers coming off into a home and removing the guns and then giving them back, we can strengthen that language to enable that the chief firearms officers, if there are risk factors, would normally refuse a license, and there should be more of a burden to allow the granting of a license in those circumstances.
Thank you for that. And you mentioned in your list of amendments you went through, and I was trying to scribble them very quickly, and I missed a couple. So I hope the one you just mentioned there about the chief firearm officers wasn't Section 36. If it is, I'm going to ask you to repeat yourself, because I missed that amendment. Could you just repeat that part when you said about Section 36, because I didn't get a chance to get that down.
So that would be, let me just. So when there's a protection order that's given to imposed on an individual, the chief firearms officer, oh, sorry, no, that's a different one. So in one of the sections, if the chief firearms officer is written determines that there was domestic abuse or stalking, they need to revoke the license. And that is a really good thing, but because we have some provinces now who have appointed chief firearms officers with the explicit mandate to protect gun owner rights, we feel that allowing one individual to determine is too subjective, and it could be strengthened by inserting a more reasonable standard. So if the CFO, for example, receives information that any reasonable person would consider to be a case of domestic violence, then he should revoke the license.
Thank you for that. Ms. Hennigan, if I could, please. You mentioned quite clearly that the screening system is flawed. Obviously, by hearing what you went through and how this, the shooter, some of his actions prior, I agree. Could you expand on that, what you think would be flawed and what changes we could do to help strengthen that?
Yeah, I'm actually going to defer that question to Heidi because she's pretty excellent with the ins and outs of the screening. That's not really my my area of expertise. While I think it's important, she's better suited to answer that question.
Well, some of the things that could be improved in screening, for example, right now, somebody who suffered from mental illness associated with violence is a factor to consider. We would argue that it should go further. That you could have Alzheimer's, or you can be an alcoholic and have serious mental health issues that aren't necessarily associated with violence, but would still justify somebody justify the removal or having not access to firearms. So that's one example of what could be tightened up in terms of screening.
Thank you, Mr. Shipley. We go now to Ms. Demoff. 6 minutes, please.
Thank you. And thank you to all three witnesses for being here and sharing your stories, which can't be easy, but it's important for us to hear from you. So I just want to begin by thanking you. My first question has to do with a provision in Bill C-70 or C-21 that is about when a chief firearms officer, and quoting it says, a chief firearms officer may issue a conditional license despite a person having engaged in domestic violence if the revocation constitutes a virtual prohibition against employment in the only vocation open to the individual. I know in speaking to the women's shelter in my riding to Halton Women's Place, the women that come to their shelter are women who are in a abusive relationship with someone who works as a police officer or a correctional officer, and so that firearm would remain available to that individual because of their occupation. I'm just wondering if you feel that condition should be removed.
The question, that's one of the amendments we're proposing, is to remove that exemption. We don't understand why the life of a potential victim is less important than somebody's job. I don't believe that a police officer or security guard it's impossible for them to find another job in a temporary way too, because prohibition orders are temporary. And so, yes, we would definitely argue for the removal of that exemption. And I think, I don't know about in Canada, but I know that in the United States, domestic violence and abuse is higher among police officers than amongst the general public. That's a well-documented fact. And another reason why this exemption shouldn't exist.
It to me that if a police officer was or someone who used their car for work and was charged in Ontario, your car will be impounded and you lose your driver's license. We don't allow them to keep their driver's license just because of their job. So they might be put on desk duty, for example. So, I mean, I think when we're talking about a woman's life, it should certainly be taken into consideration. Did you want to add anything, Ms. Hennigan, or is that a...
No, I'm in complete agreement. There's no single job that needs you to have a gun that, it's the only job you're ever going to have in your entire life. It's absolutely ridiculous to think that, jeopardizing someone's job over someone possibly dying is important. I completely agree with Heidi. I think that should absolutely be removed.
Thank you. On red flag, I want to push back a little bit on this because I have heard cases where women are not comfortable calling the police. So the provision in the bill was not meant to replace that, but to provide an additional tool. And I think it was a year or two ago, there was a woman in the North, Indigenous woman, who called the police, and she ended up being arrested because she had breached her parole because she'd been drinking. So someone like that is never going to feel comfortable calling the police to have the firearm removed. So giving people like that an additional tool, or the situation we just talked about where the abusive partner is a police officer, that woman is never going to call the police, but she might go through a woman's shelter or go through the courts to have that gun removed. So I guess I just wanted to push back a little bit on that to say, do you see situations like that where the current provisions don't work?
Position to comment on specific cases. All I can say is that on balance, we feel that the existence of such a measure will undermine the reforms that need to take place in those kinds of cases where police don't take complaints seriously enough. And that should be the focus of improving the system, because that is the most effective system in terms of protecting victims and potential victims, especially of domestic abuse. And it might distract from we have the tools, but they're not being used properly, and that is the best solution. And we feel that having this nice sounding red flag measure it would jeopardize what needs to be done to improve the system.
One of the things the Canadian I only have 30 seconds left. The emergency room physicians have asked for an amendment that would give them a mechanism to identify and report individuals at risk of inappropriate access to firearms. Are you supportive of an amendment that would allow physicians to report?
We support the position of the Canadian Association of Emergency Physicians. In Quebec, we have the anesthesia law, which allows such a thing. So I'm not sure about jurisdictional issues, but certainly doctors, especially emergency doctors who confront these at-risk individuals, should be able to report them and trigger action in a timely manner.
Thank you, Mr. Muff. We go now. On y va maintenant, Madame Michaud. 6 minutes.
Now over to Ms. Michaud. 6 minutes, please. Thank you, Mr. Chair. Thank you, ladies, for your testimony. And thank you for your courage and your fighting over the last 33 years. I know that the legislative changes, well, you've been waiting for them for a very long time. And unfortunately, C-21 doesn't seem to be sufficient. And you'd like to see some changes made to this bill. At the same time, we're receiving requests from other groups who would like us to go in the other direction. You know as well as I do that the International Shooting Confederation is asking for an exemption for the handgun freeze. Can you please explain to us, if we exempted as many groups as possible, why that wouldn't be a good idea? And I agree that if we did that, it would make the freeze almost useless. I'd like to hear your opinion on that.
Merci pour la question.
Thank you for the question. You know, currently, a large majority of handgun owners say that they have them because they're a member of a shooting club. That's the case for most of them. A group like IPSC, the International Practical Shooting Confederation, which is funded by the weapons industry and which uses assault weapons, and they play games that are on the, on the spectrum of, well, they're on one end of the spectrum and the Olympics are at the other end of the spectrum. They do scenarios like hostage taking and home invasions and things like that. If this group is exempted, well, there could be IPSC competitions in all shooting clubs in theory, and all other handgun owners could technically be exempted as well. And that's what one of their leaders even admitted. So it would make the measure completely void. The goal is to limit the number of handguns and to exempt some sports with these handguns would be, would be maintaining status quo. What worries us is an increasing desire of Canadians to protect themselves with weapons. We hear it, we see it, in the media, and the biggest danger with exempting all kinds of cases is this philosophy of wanting to protect oneself with the use of arms and making that more and more of a legitimate option among citizens. Now, firearms have always been present in Canada, but for hunting, it's not for protecting oneself. This is not one of the strategies or values in Canada when it comes to firearm use. So for us, assault-style weapons, handguns, the more they're frozen, the fewer exemptions there will be, and the stronger the act will be. Thank you. And we can see that in Montreal, what's been happening with there have been some gun-related incidents, and young people are getting involved in gangs. And other young people could get interested in this idea of acquiring a firearm to protect themselves, a bit similar to the American culture. And to reinforce this measure and making it an annual process, so that somebody gets a letter. So it's not a lifetime duration to limit the number of people who have access to the firearms. And there was another point. There was another measure, pardon me. You talked about Olympic disciplines and those who are currently enrolled. And perhaps you could elaborate a little bit on that one, because you mentioned on that, and I want to know what change you're proposing. Yes, about the Olympics. I understand that it's a source of pride, Canadian sports shooters, and I had the privilege of talking to one when I was part of the Firearms Committee. I would go so as far as to require that the Canadian Olympic Committee for Firearms guarantee the security of all those who want to be involved. So making them responsible for their own members, because I can understand that people want those individuals, but it means a huge amount of responsibility if you want to become a shooter. So in my opinion, and I understand why there's an exemption, but this exemption must be accompanied by a serious level of accountability. One of the things that's happening is that groups like SECU have been lobbying for decades to become an Olympic discipline. And they have made inroads. They've become recognized. In fact, like ours, well, we're not in the same circles as them, but it's very possible that there will be new competitions that use firearms. And the way the bill is written currently, they would be exempted. So we're saying, let's limit ourselves to what we have right now, the Olympic sports. And the other thing is we're trying to see how we could prevent abuses. So all of a sudden, if all sports shooters want to become Olympic shooters, well, there's no standard that we're aware of. Well, we can't doubt, this legitimate interest of these individuals. So will there be a new wave of interest for Olympic shooters, and then they'll get exempted to purchase any firearm because the act doesn't limit them to handguns or firearms used in the Olympics? So there are scenario possibilities that mean that the exemptions could be abused. And essentially, it wouldn't respect the intention of the legislator.
We go now to Mr. McGregor. If you please, 6 minutes.
Thank you very much, Mr. Chair. Thank you very much for appearing today and helping guide this committee through our study of C21. I took note when you were making your opening remarks, when you made reference to the May 30th press conference announcing C21. And I do remember Minister Mendicino making a promise, I believe it might have been to a reporter's question, about bringing in an additional amendment. And I know, and thank you also for providing me, my office, with a list of some of the ways that C21 can be strengthened. You identified the fact that there's a problem with the definition of prohibited weapons. And I find that this is a constant with all legislation. When you try to make a list of something, there's always the danger that you're missing out on something or that it can be expanded. And I think that's why when the original OIC, was at around 1,500 and now it's climbed to 1,800. But of course, manufacturers can exploit loopholes by simply, well, we've got a new model, it's not on the list, therefore it's allowed. So I guess we haven't yet seen what this amendment will look like. I expect my Liberal colleagues are hopefully working with the Minister of Public Safety to bring forward what he promised the public. But in your mind, can you help guide this committee as to how you would like to see that definition be included? If you could share any thoughts to help guide our committee into that particular amendment.
Thank you for the question. You're right that having a list of prohibited weapons is what happened. In fact, that's the approach that was taken in the 1990s. and the lists were never updated. So having just lists means you depend on future governments to update the list, which was not done under either governments. And that's how we found ourselves years later with a market full of military-style semi-automatic assault weapons. In terms of a definition, now we're not ballistic experts. We know that these semi-automatic military-style weapons, what they're capable of, especially with large capacity magazines. These same weapons that are used in the United States and in all these mass shootings were legal here. Some continue to be. And in terms of definitions, well, there's different ways to go at it. The Bureau of Alcohol, Tobacco, Firearms, and Explosives in the United States has a list of criteria that can be used to determine whether or not a weapon is military style. I think California also has a definition that is all semi-automatics that can accommodate magazines that have at least one other military feature. So that's probably as far as we would go. We would point also to the New Zealand model, which is most center-fire semi-automatics that can accept large capacity magazines. But that's pretty much as far as we can go. But like Nathalie said and Megan said, if a gun is able to be used to kill dozens of people in a matter of seconds, it should not be in the hands of an ordinary Canadian. And we will defer to the experts of your experts and the experts of the government and the RCMP to draw that line, which we know won't be easy. But currently, the Orders in Council and the little bit of the criteria that's in there do not cover all assault weapons, and that needs to change. We've been fighting for that for 33 years, and that's our top priority.
Thank you for that. In my remaining time, I think with the red flag laws, that's something, and I think I can speak for all committee members, we've really been struggling with, just because we have had testimony on both sides of the issue. I mean, we had police services here say, well, it might be nice to have an additional option, and of course, if someone's life is in danger, they should always go to the police first and foremost. So it's hard for us to navigate this. I just want you to know that the committee is struggling with this, with the question of what to do with the red flag laws. However, in your submission, you did call for the removal of several clauses for the majority of the red flag laws, but you did say you do support prohibition orders against individuals cohabiting with someone prohibited from owning firearms. You think that should be retained. Can you expand a little bit on that for us, please?
It makes sense that if somebody is prohibited from owning firearms for public safety reasons, that they shouldn't have access to firearms. And if they live with somebody that has firearms, that's a problem. And so that was inserted in the ex parte red flag measure, and that was one element that we felt was helpful, and it should be maybe removed from that section and added to another section to keep it in the bill.
I think the issue is that, like, in some cases, the police may not take complaints as seriously. How do we further the national conversation on that, so that people can be sure that when they do make calls to the police with legitimate concerns, they're acted upon? I mean, so they're not having to use this alternate route. I don't have much time left, but.
Well, we did. It's not part of the bill, but we've said many times that there needs to be more training, more resources, one for better screening and two for better preventative intervention, including training for judges and police officers and firearms officers.
Thank you, Mr. McGregor. We'll start our second round of questions now with Mr. Shipley. Mr. Shipley, please go ahead. 5 minutes.
Thank you, Chair. And Ms. Hennigan, I'm going to start with you again, because in your opening statements, I didn't quite catch what you said. And if you could expand on it, and if I'm misquoting you, please correct me. You mentioned something about practical or shooting games. Could you just expand on that? First of all, if I said it right, and what you meant by that?
Yeah, so if you think about practical shooting, the tactical shooting, it's basically a bunch of guys who want to go in and play good guy with a gun. You practice all of the so-called, self-defense measures that are used, um, especially in training with law enforcement and all of that. Like when you think of American gun nut, that's this guy is the image that comes to mind. In Canada, it doesn't make sense to even have these as, as a sport, as a game that people will go play. One, because guns are not toys. And two, because we do not have the same rights to self-defense as the US, never mind the rights to guns. If some guy came into my house right now and tried to steal my TV, if I shot him, I would also be in trouble. I don't have the right to use excessive force against someone if running away is gonna do just as good a job, you know, protecting myself. So going out and, playing the big tough macho man who shoots down all these bad guys, it's not a game. It's not healthy. It doesn't encourage, a very community safety minded environment. And I don't really think there's a place for it.
Thank you for that. I'd like to ask you a question. I hope you please don't take this the wrong way. I'm doing this because we're trying to get down. Oh, you got a little friend there with you. Trying to get down to some. I'll just wait till you get settled.
Sorry about that.
No, that's okay. Life carries on. Sorry, I got a little distracted there by the baby. You can see I'm just a big softie in there. Eh? So I'm going to bring up. I really don't want to talk about your incident because I'm sure you don't want to talk about it either. But I just have to ask a couple questions if you don't mind, because you mentioned that this horrible human being who caused this to you didn't pass basic training. Just recently in South Simcoe, the person who shot the two police officers did not pass basic training too. Do you know anything about, and if you don't, I understand. If you don't even want to talk about this, I understand too. But do you know anything more about that, why he was kicked out? And perhaps we should have some communication. When I say we, I'm talking about the government. I'm not talking about me and you, as to when someone's removed for certain reasons, and we don't know why they're removed or don't pass basic training, that perhaps that should be flagged and put on, because there's two instances here that, one you've talked about, and the second, as I said, just was recently with the incident of the two tragic shooting of South Simcoe police officers. He was also removed from basic training. Do you know anything about the surrounding that case? And perhaps if we don't, we need to start communicating about that when that takes place. Maybe that's a flag, is what I'm trying to say.
It definitely is a flag. If the Army doesn't want you around its weapons, you probably shouldn't be around any weapons at all. I'm not entirely familiar with the reasons why he would have been kicked out of basic training, but I do know that, it takes some pretty serious stuff for them to kick you out before you even get halfway through. There was a lot of mental health concerns in the past that were brought up. And if the Army says they don't think you're fit for duty after actually having accepted you, that definitely needs to be looked into when you're looking to own a firearm, because there's a reason they didn't want you around theirs. I think it's really important that all of these different systems be able to communicate with each other, because right now they're not. And so, you can pretty much go through life just, if you're in this one spot and that happened, and you move to another spot and you try again, you may have very different results, right? Once if you're somewhere where, the doctor needs to be able to report, or, there needs to be a database of reasons that someone was kicked out of basic training, or, maybe if someone was asked to leave a gun club. These are important measures that need to be addressed, when someone is looking to buy something that's as dangerous as these guns are.
5 seconds.
Thank you for that answer. I do just have to add, I don't know if, and this is nothing to do with your case in South Simcoe, if the firearms that he used were legally purchased either. So he may have been illegally purchased, which wouldn't have helped in a situation where they red flagged him. But thank you for all your information. Once again, thank you for being here today.
You're welcome. Thank you.
Thank you, Mr. Shipley. Also, the clerk has just advised me that you have a 4-month-old that you're working around the exigencies of that, and your father has come to help you out. So,
Yeah.
congratulations.
Thank you so much.
On y va maintenant, Madame Mondayan.
Merci beaucoup, Monsieur.
Now over to Ms. Bandayan. Thank you very much, Mr. Chair. And I'd like to thank the witnesses as well. The women from Police se Souvient. I don't have the words to express myself, but I would like to once again thank you for the exceptional work that you are carrying out so that the tragedy that happened in Outremont 33 years ago never happens again anywhere in Canada. I'd like to come back to an issue surrounding sports shooters. It was raised earlier. The bill has an exception for people who train in an Olympic sport. We know that. But certain members of the opposition, including the NDPR, are requesting an exemption for competitions organized by the International Practical Shooters Federation. We know that this has become a very big, there's been a lot of support for this, and this would create a loophole for the handgun freeze. And even the Federation said that if the exemption, the expanded exemption takes place, it would be the entry point for possessing a handgun in Canada. And that's very worrisome, especially since we know that 80% of Canadians want stronger control measures for firearms. You already spoke about this, but do you have any comments, additional comments around the dangers of such an exemption? The only thing I would add, first of all, the majority of Canadians want to ban firearms used for these types of sport, but also most firearm owners are for an assault weapons ban. And between half and 2/3 of these firearm owners are against handguns. We're talking about a minority of firearm owners who use handguns and assault weapons in order. If we look at all of the shooters in the sports field, in that category, there's another minority of individuals who, take part in police or war games or self-defense games. What I'm trying to say is that it's this community that makes up the firearm lobby. They are the firearm lobby, and it's funded by the firearms industry. And if you give an exemption to sports shooters, which is at the far end of the legitimate use of firearms because it's part of the Olympics, then that cancels out the measure. And the current holders, handgun owners, can keep their weapons and engage in sports shooting. We just don't want things to get worse and for shooting clubs to become the place where people can practice this type of sport, an American style. I'd like to come back to my colleague's point, what Mr. McGregor said. He brought up the amendment to strengthen the assault weapons ban, and that was among your first recommendations. So to answer my colleague, yes, we're working on that amendment. This is a top priority for me personally and for our government. Can you please lay out for the committee how important such a measure would be? After the Polytechnic events in 1990, is that this type of weapon needs to be banished from Canada. This is the request we made. We were students. We have photos of myself and Heidi and our other classmates. We were 22, 23, 24 years old, and that's what we're asking the government of Canada to do. We didn't ask this all on our own. At the time, internet doesn't exist. Online petitions didn't exist, and we did this. Well, it was the largest petition that had been signed by all Canadians. It wasn't just a request from Quebec or Montreal, all of Canada. And that's how the Coalition for Firearm Control was created. And it led one day to the creation of Bill of the Act on Firearms, that of 1995. But at that time, because we had seen in the registry a good option, we didn't go all the way and abolish assault-style weapons. The market changed and evolved, and today we're faced with a pandemic, a firearm pandemic. It's really a pandemic. All countries across the world are dealing with this pandemic. Firearms have become a everyday toy, and people want to have them. So it's fundamental because for Police se souvient to accept this act, there has to be a strong amendment that completely bans and that there be a mandatory buyback program for all assault-style weapons. For us, this is a no-brainer. It's fundamental, and it's a demand. The parents of the Polytechnique victims are dying, and they will never even see the success of their efforts after all these years. It needs to happen today. The more time goes by, the more it will be important for a government to legislate rigorously and at a reasonable cost. So it is absolutely critical that in 2022, a bill include a definition and prohibit completely all assault-style weapons. This is critical. And for me personally, this is the only condition under which I can support the government.
Bandayan.
Thank you, Ms. Bandayan.
We have to cut this round short. We'll have to end it after Mr. McGregor. On y va maintenant, Madame Michaud. 2 minutes et demi, s'il vous plaît.
Now over to Ms. Michaud. 2.5 minutes, please. Thank you, Mr. Chair. And thank you, Ms. Provost. You can count on the Bloc Québécois to table such an amendment if it's not done by another party. Madam, you mentioned that during a study on firearms and street gangs, you mentioned that all magazines should be limited to 5 bullets and that the market is able to adapt to that. The government issued a first regulation that governed certain magazines, but it took 4 years last time before the regulation came into place. Are you confident that this will happen quickly, or are you finding that we should find another way in C21 to make an amendment so that this subject be better addressed rather than waiting for regulation? What do you think? Ideally, such a prohibition should be in the Act. That would be stronger. The government said it would do it through regulation. It's currently a regulation that bans these types of magazines. Our recommendations are in that spirit. But there would be good reason to include it in the Act. It would be harder. In fact, in the past, the federal government, under another party, had provided the interpretation or had created the interpretation that went against the legislators' intention. It was Kim Campbell at the time. In the media, it was said that it was ridiculous. But the loophole and the exemption said that if a magazine was not designed specifically for that firearm, then it was exempted from the limit. So it was absolutely absurd. And so we believe that a future government could have more flexibility with such regulations compared to with a law. So if possible, though, yes, we'd like to have it included in the law as well. And to conclude, I know that when we decide to get involved in politics or to lead a movement, sometimes we receive negative comments or threats. And I know that you have been the target of that because of your advocacy, and that's very unfortunate. Sometimes it might be because the person is just lacking knowledge or awareness. Thank you, ma'am. Oh, I would have really liked to have asked my question.
Gregor, 2.5 minutes, please.
Thank you very much, Mr. Chair. I remember, I think it was in your opening comments or in response to one of my colleagues' questions, you were talking about, I think it was Section 34. And I think you had referenced the fact that, like, some chief firearms officers in certain provinces have shown a willingness to be confrontational with the federal government, even though, both the Criminal Code, the Firearms Act are entirely federal jurisdiction. And I think one of your recommendations, and this is specifically to the yellow flag law, is that you wanted the word changed from not from may suspend use, but to shall. Can you maybe expand a little bit on that? I guess you're wanting to take away any ability of the CFO to have some leeway in that. Can you expand on it a bit more?
Well, after 33 years of experience, we know that legislation needs to be rock solid, and that any gray zones or discretion can be exploited, and often is, depending on the values of the governments that are in place, whether federal government or provincial governments, like we now see in some of the western provinces that have appointed chief arms officers because of their involvement in and ownership of guns. And explicitly to protect gun owners' rights, right? And so the more that there's may, words like may or could, the more the chances are that these authorities do not err on the side of public safety. And so if a chief firearms officer has reasonable grounds to suspect that an individual is no longer eligible to hold a license, well, why would the possibility of allowing that individual to keep their license exist? If they're not eligible, the license should be revoked. It's that simple. And so tightening up some of the languages, and this is one good example, would go a long way to ensure that public safety is a priority.
Thank you. I'll just end by thank you for your appearance today, and I think there will be a willingness to tighten up language in some of these sections for sure. So thank you.
Thank you, Mr. McGregor, and thank all the witnesses for joining us today. Your interventions are most helpful and most important, and with that, we will suspend to bring in the next panel. Thank you all. with us for this panel by teleconference, we have in this second hour, we have the Airsoft Association of British Columbia, Scott Hackenbrook, Director. And with us in person, we have from Canadian Airsoft Imports, Matt Wasilewicz, owner and president. So I'll invite each group to make a statement of up to 5 minutes, and we will start with Mr. Hackenbrook to make an opening statement. 5 minutes, please.
Yes, hello, and thank you for having me here to talk about Bill C-21 and its impact on airsoft. My name is Scott Hackenbrook, and I am the director of the Airsoft Association of British Columbia. I've played airsoft for over 15 years and have organized and run some of the largest games in Western Canada. The Airsoft Association of BC was founded to represent the players of our sport, educate the public, and work with government, law enforcement, and various other stakeholders to ensure that we can safely practice our sport and help it grow. We've seen countless stories of people whose lives have been changed for the better by this sport. In addition to being a player, business owner, and organizer, I'm also a new father, and I hope to one day be able to introduce my son to the sport that means so much to me in a safe manner, but also at the appropriate time. Some of the most heartwarming and gratifying stories to me are when parents approach me to tell me about how transformative airsoft has been in their child's life. Learning how to communicate clearly and effectively, gaining sportsmanship, building long and lasting friendships, and cementing bonds with their parents are just a few of the stories I've been fortunate enough to be a part of. We have heard testimony in this committee that has spoken to the public safety concerns that our law enforcement and officers potentially face due to the misuse of airsoft devices. We want to solve these problems in a constructive and collaborative approach. We've also heard from our colleagues in ASEC and FSAQ about the potential of Bill C-21 to effectively end airsoft within Canada. Fear, uncertainty, and doubt permeate our community. Overnight, families and businesses with life savings invested in the industry could see their livelihoods destroyed, left with vast amounts of merchandise they can no longer sell, export, or return to the manufacturers should the bill in its current form pass. This would devastate many in an already difficult economy. Prohibiting the importation, sale, or transfer of an airsoft device that is designed to or intended to exactly resemble with near precision a firearm will remove the vast majority of devices available to the Canadian market. Due to the relative size of our consumer market, it would be unlikely that manufacturers would design and build custom airsoft devices for our retailers and distributors. The broad definition would also leave it open to interpretation that anything resembling a barrel with a grip and a trigger could be considered a firearm, regardless of it being intended to resemble a commercially available firearm or not. One thing is apparent: this is a complex and nuanced issue. Airsoft is a competitive team sport that relies heavily on integrity and character. We value rules. We value safety. For the last 2 decades, airsoft has been a self-regulated sport where the community has determined the equipment and the regulations needed to compete in a safe and responsible manner. We recognize the need to work with the greater community of Canada to ensure that we can safely enjoy our sport and address the needs of Canadians. We propose one or more of the following solutions to address those needs in the short term. One, adding an 18-plus minimum age to the purchase of an airsoft device. 2, mandatory transportation in an opaque and solid container. 3, warning labels on the packaging of airsoft devices informing the end user of the potential consequences of misuse. 4, orange tips required for the sale and transport of airsoft devices. And 5, dissemination of educational materials through the retailers, local fields, and provincial associations. A more comprehensive solution may be the implementation of a national or a group of provincial organizations. To purchase an airsoft device in Canada, it would be compulsory to be a member of one of these organizations. This would remove the burden of cost for any regulatory framework from the federal government while addressing the concerns for the public safety of Canadians. As representatives of our community of players, we are standing before our duly elected representatives asking you to consider the joy, friendship, and growth this sport has brought to every one of us. It has built lifelong friendships, it has sparked entrepreneurial spirit, and led us to push our boundaries, foundational qualities that improve and enrich our community every day. We are ready to work together with you on finding a solution that will keep us all safe. I thank the committee for my time and welcome any questions you may have.
Thank you, Mr. Hackenbrook. We go now to Mr. Wasilewicz for a statement. Please go ahead. 5 minutes, please.
Hello. First, I would like to just say thank you to members of the committee for inviting me here today to speak on behalf of my industry. I am here specifically more to speak on airsoft, but I would like to make a point that has not been touched upon too much, is that this bill affects not only the entire airsoft industry, but traditional BB and pellet guns as well, which are also very popular and common in Canada, although I am here to speak more specifically on the airsoft industry itself. Just a quick background from my experience in the industry. I have been involved in both the paintball and airsoft industry now for the past 25 years. Since 2009, I have owned a paintball and airsoft playing facility as well as a retail location. And since 2012, I have owned Canadian Airsoft Imports, and we are one of Canada's largest importers and distributors of airsoft products in the country, supplying approximately 150 retail locations and playing fields from coast to coast in Canada. I was going to give you a quick background on airsoft, but I think at this point, most of you are pretty aware of what airsoft is. It's a team sport, played very similar to paintball as a game, and the majority of airsoft is played on designated airsoft playing fields, either indoors or outdoors, both in cities and in rural areas. As an industry, we definitely understand there are public safety concerns that must be addressed, and I would like to stress that in consultation with other retailers and importers in this industry, we are very committed to working with the government to find solutions which will both address these issues and at the same time allow our industry to continue to prosper for everyone. I guess I will go at this point. I'll just go over some of the proposals that we have come up with. So in my brief, I have listed these proposals, but I'll go over them here now. I have divided them up into two categories. One would be more basic proposals that could be implemented without extra administration or extra cooperation with a government entity, and ones that do require extra administration or cooperation with a government entity that would need obviously a little bit more consideration to implement. So in these basic proposals, these have been touched upon numerous times now, but I'll just list them again. Our industry 100% supports making it clear and concise that the purchase of any air gun in Canada should only be to individuals who are over the age of 18. It should also be clear and concise that transportation of air guns should be done so in a way that conceals them from public view, either in a gun case or in a concealed container, similar to what you would already do with a real firearm. Another change that we are able to make would be the addition of brightly colored orange tips that are on the end of the guns. This helps in aiding identification at a quick glance from a distance. Another proposal that our industry very strongly supports is the standardization of a do's and don'ts waiver, as I would like to put it, that is mandatory to be signed with the buyer at the point of sale. This has a twofold benefit. One would be education to new players and new users who are getting into the sport, as I believe the best course of action to stop any honest mistakes with airsoft or air guns in general is through education and making sure that people who purchase these items know what is required of them for owning such devices, such as safe transportation and storage and that sort of thing. The other thing that having a waiver like this at point of sale where someone has to sign and obviously show ID at the same time is that this also, I believe, would act as an effective deterrent to a lot of people who would perhaps maybe have ill intent to use with an air gun. So I do believe this could also be a deterrent as well for that type of situation. Another proposal that I have, this comes from more of my background in the paintball industry, and that would be that air guns should be sold in the packaging with what's called a barrel bag. If any of you have ever played paintball or seen it, the barrel bag is a device that goes over the end of the barrel. It is attached to the end of the gun. It's usually brightly colored, and that is, at least in the paintball industry, and a lot of airsoft fields do this now as standard practice. It's to basically show everyone that the gun is safe, and that it cannot shoot or usually in like staging areas, so it's safe and accidents can't happen.
Are you able to wrap up quickly?
Sorry. And my advanced proposals, this one has been brought up to me before a couple times with my conversations already with Public Safety Office. That would be adopting a more comprehensive model, which kind of includes all of the above, such as the model that's used in the UK. It's a two-tier system. Access to a weapons ban list. I don't know if a mechanism like this already exists, but I'm sure retailers would like to have something like that at their disposal as well. That could also be useful. That'll conclude my opening statement for now.
Thank you. We will now start our round of questions with Mr. Lloyd. Mr. Lloyd, please go ahead. 6 minutes.
Thank you, Mr. Chair. Can't say I'm an expert in airsoft myself, although I have paintballed a few times. But it seems to me that there's law enforcement had a few concerns. So their one concern is that there have been cases where a police officer has mistaken an airsoft gun or a replica gun for a real gun, and then a tragic thing happened. Is this something that is common, or is this an extremely rare event?
Question directed at me?
Sure. Yeah.
Okay.
You.
I don't think it's as common as maybe we would think, but I think law enforcement would probably be better to answer that question. They would have the statistics on how often that happens. I do believe that in order to avoid situations like that, having distinct markings such as brightly colored tips, or going a step further with the two-tier system that the UK uses, is probably a more effective approach to reduce that type of situation. Education to the consumer at point of sale is also going to be very effective.
I would agree with you.
Yeah.
I think that in the Army we use BFAs, they're called, at the end of our rifles when we're shooting blank ammunition. It also shows that the rifle's safe at the time. So using a brightly colored tip on an airsoft seems like a kind of a reasonable compromise to be made. Although if somebody is intent on, using a replica airsoft firearm in a nefarious way, obviously they could spray paint the brightly colored tip on that. There's nothing that, law-abiding, fun-loving airsoft people can really do about people who are determined to use airsoft guns for bad purposes. Is that correct?
To be mostly correct. It's very difficult to regulate criminals because they don't follow the laws in the first place. Our proposals are more focused on reducing honest mistakes amongst people who don't have any ill intent, who maybe just didn't know the rules and didn't know what procedures they need to follow when it comes to the use of airsoft or air guns in general.
So what we're looking at is like an industry that is overwhelmingly safe. The data shows that it's an overwhelmingly safe sport to play, that the members who play in the sport are competent people who aren't engaging in criminal activity. And yet we're contemplating legislation that will, in your words, or one of the witnesses' words, completely end the sport of airsoft in Canada. Do you think, like, one of the things as government and when we're making legislation is proportionality? Do you think this legislation is disproportionate in banning airsoft in Canada?
Well, as currently written, I would definitely have to agree with you. It's not even disproportionate, it's totalitarian. It completely closes our entire industry all at once. So that's why we're committed to working with the government to finding solutions that do address legitimate public safety concerns and at the same time will allow our industry to continue.
And we're talking about, like, what are the monetary figures we're talking about, the GDP figures of the airsoft industry in Canada? Do you have an estimate on that?
My best estimate would be over 200 million, and that is factoring in playing fields and retail locations. This is just kind of based off of what I know my business imports and what my the types of business that my customers do and other importers. If you were to factor in the other industries, though, that are also affected, such as more traditional BB guns and pellet guns that you'd find in like Walmarts and Canadian Tires, that kind of thing, that figure would definitely grow significantly.
Now, a second concern that law enforcement had is the ability to convert airsoft into a regular firearm. As far as I've seen, it's not like you can convert an airsoft easily. And if you could convert it, we're not talking about heavy calibers. I think we're talking about 22, which is a pretty small caliber of firearm. How prevalent is the conversion of, and frankly, why would anyone want to convert an airsoft gun to a regular firearm?
So to answer the second part of your question first, I think the only reason you'd want to do that is if you were a criminal wanting to have ill intent. But as far as the convertibility goes, this really only affects a small percentage of airsoft guns that are available, and that would be typically guns that are what's called gas blowback. They operate on a gas function rather than electric, which is about 90% of the market are electric airsoft guns. This is something that the RCMP already has quite a good handle on.
So I've only got 30 seconds left. If there was a proposal where the regulations only applied to these gas blowback powered airsoft guns as opposed to electric guns, would that be a positive thing for your industry? Is that something that you would support?
That is something we could support because the mechanism already exists to determine if they're allowed or not. It's called getting an FRT number. So typically when something is imported, if there's a question, it's submitted to RCMP lab. They do their studies on it and they assign it an FRT number, either giving it basically the all clear or determining that it does pose a risk. And this is something they've been doing now for quite some time. It's an ongoing process.
Thank you, Mr. Lloyd. We go now to Mr. Nur Mohammed for 5 minutes, please.
Thank you very much, Mr. Hackenberg and Mr. Veslowitz. I hope I got your name right. I wanted to actually begin by thanking the both of you for putting forward what I think are some really good ideas in terms of how we can ensure the longevity of your sport. I had the pleasure of meeting with a couple of other individuals yesterday from your industry who shared similar views in terms of finding ways to work with government, which I think is really important. I want to be very, very clear that my intent, and I think the intent of many of us, certainly all of us on this committee, is not to kill the industry. And so I think the proposals that you are making are really, really important in helping us get to a good place around ensuring public safety and respect of your industry. Can you talk a little bit more about, you had mentioned in terms of carrying these guns and making sure that they are carried in a similar manner as live round firearms. Can you talk a little bit more about what you're proposing there? And can you talk a little bit more specifically around the potential registration when these items are sold to 18 plus? What do you think the industry is willing to do in order to be able to address those two specific things? Just elaborate a little bit on what you had talked about first. Maybe Mr. Hackenberg, you can lead off, and then Mr. Veslowitz, if you've got additional comments on that.
Sure. As far as transportation, many of us already purchase plastic cases that are opaque in nature, usually intended for traditional firearms. Transporting in those, they allow for a lock to be attached so that the case can't be opened quickly, and we use those if we're transporting them on aircraft to go to international events or crossing the border. We feel that would be a good way of the devices not being accidentally seen or waved in the public and causing unnecessary scares, as it were, and escalating a situation beyond what's immediately required. Forgive me, I forgot the second half of your question.
Yeah, the 18 plus piece, and then ensuring
yes.
that it remains regulated.
So there are a number of options we could look at. The two largest that sort of spring to mind is the United Kingdom has something known as UCARA and UCAPA. They're two associations that work with each other, UCARA being retailer-based, UCAPA being the player version of that. In order to purchase airsoft guns, you would need to be a member of UCAPA. In order to sell them, you would have to be a member of UCARA. There's also the Netherlands, which uses a number of local associations to effectively do the same thing. So the associations would be responsible for maintaining records as well as an age verification system to ensure that those purchasing the firearms are 18 or older.
Thank you. And Mr. Westlowitz, do you want to add anything to that, or should I go on to my next question?
I just think for transportation, the best way to get those rules across that players know is at point of sale through the waiver that we had discussed. I think education is probably the best approach to make sure people know that. And I do agree that the two-tier system that is used in the United Kingdom is probably the best approach to ensure that after sale that there's still regulation. Basically what that concept ensures is that only people who are dedicated to the sport are able to purchase normal airsoft equipment as we see now, and those people who aren't dedicated, maybe just the casual user, are basically only limited to purchasing very brightly colored and evident that they're not real airsoft guns, and that's usually with a very bright color covering about 50% of the surface area.
So just digging in a little bit now, one of the questions I think is, I think it's, if we're able to proceed and it's 18 plus that does the purchase, that's great. Now, how do you make sure, or what do you think the industry is willing to do to make sure that when those guns go home, that, 18 plus dad or mom buys it, it's sitting around the house, and now a kid picks it up and takes it to school? And we start to see some of the tragedies, just like the one we saw not long ago. How do you, or what do you think the industry is prepared to do? What would the industry be prepared to do to ensure that that doesn't happen in terms of working with government? What recommendations would you be willing to make or work with such that we avoid those types of certain circumstances from happening, and certainly sometimes with tragic consequences?
Well, I think, it's very difficult to police what people do in their own home with their own children, but making it clear these devices are intended for adults, I think is part of that, and restricting the sale to 18 plus, and instructing the purchaser that this is the intention, they're meant for adults, not for children. I think that goes a long way towards that. Again, I don't know what we could do once it's in a private home beyond explaining to people what the laws are, and if they choose to violate those laws, I don't know how to stop that.
What about storage requirements similar to what is currently required for folks that have live round guns at home?
I think that's definitely a potential option to pursue. I know for myself, my stuff is always stored in its case and is placed on very high shelves so that my 1-year-old can't ever get a hold of it. I think that's a perfectly reasonable solution, is making sure that they're stored in a way that they can't be improperly accessed by the wrong parties.
And just to the second part of the conversation we just had prior, we talked about, I think, Mr. Westlowitz, you talked about having brightly colored, 50% of the weaponry.
Mr. Nur Mohammed,
colored.
I'm sorry, yes. Time's up.
Okay, all right, thank you.
We go next to Madame Michaud. 6 minutes, s'il vous plaît.
Ms. Michaud, 6 minutes, please. Thank you, Mr. Chair, and thank you to the witnesses for your presence. It's very appreciated. We also heard from the Sports Association of Quebec, the Canadian Airsoft Association as well, and we very quickly understood that your industry had not necessarily been consulted before the tabling of this bill, and I understand that that is what you have felt as well. Perhaps the airsoft industry was unjustly targeted by this bill, and very quickly proposals were made in order to find a compromise. The bill deals with prohibited arms, and airsoft has been targeted by this, but there have been other possible regulations explored so that these sports can be practiced without forbidding them completely, and I feel that that's in line with your proposals as well. Now, since the beginning, of our time with you. I've been listening to you, but I think it's important to look at what's happening elsewhere. As elected officials, we're not specialists on all topics, of course. We become specialized in some, but thankfully we have experts and analysts from the Library of Parliament who help us out and provide us with information briefings. And we saw what happens in New Zealand. You talked about this a little bit. And I'm going to ask you about how it works elsewhere. And I'd like to know if you'd be in agreement with this type of proposal or with what's done elsewhere. If I start with New Zealand, airsoft arms are not considered a firearm in New Zealand. You have to be at least 18 years old, or you have to have a permit or a license to have this type of firearm. I think you would agree with this type of regulation, right, around the age, the 18 years old in Canada?
Making 18 plus in Canada.
Je comprends que c'est assez réglementé au Royaume-Uni.
In the UK, it's quite regulated as well. And what I found interesting is that we often talk about the orange tip, which can distinguish airsoft arms from regular firearms. And what they do in the UK, it's impossible to add green and blue or with orange included. In fact, and it's very clearly indicated that it's not a real firearm. If the government put in place a regulation that would require providers to sell the arms that are configured differently with colors, is that something that you'd be in agreement with?
The system in the UK is a two-tiered system. So if you are not a member of the UCAPA organization, you have to purchase what you're specifying, a brightly colored variant, as it were. Membership would allow you to purchase the sorts of devices that we presently have in Canada. So there is a restriction there. We are open to the discussion of that sort of a system, of a two-tiered system that allows for that methodology.
In consultation with the various retailers that I deal with on a daily basis, most are definitely supportive of trying to adapt a two-tier system as they do in the UK. I do believe it is probably the most effective and comprehensive solution to address all of the issues. I just think if that were to be the direction, further consideration would probably have to be given to how that would be implemented to other air guns that are affected by this industry, because airsoft is primarily sold through very specialized stores who are able to accommodate this sort of solution, which we definitely can and would do. But larger big box retailers that sell traditional BB or pellet guns might have significant challenges to adapt to a solution like this. So we would have to either do something extra for them or make some sort of distinction between airsoft and traditional BB and pellet guns as well. So I don't know what that would be, but further, thought would have to be put into that as well, I think.
Merci. Et finalement, il y a
Thank you. And lastly, some businesses, well, we would get a lot of emails with suggestions, especially concerning, transporting and storing. You talked about different bags or containers for transporting the guns. And some businesses told us that for them, the most efficient way to make sure that the other suggestions as proposed by SECU and others would be to restrain the access to these guns, and that this should be done through a intermediary in Canada. What do you think about that?
Forgive me, I'm not sure. I'm not sure I quite understand what's being asked.
I'll try to clarify. It seems unanimous that you don't understand what I asked. Okay. there's a desire to regulate the imports. So if the sales came from Canada and not from elsewhere, if it was only in Canada, I don't know if I'm saying it well, but do you see a little more what I'm saying now?
I understand the point you're trying to make, so that if their product can only be imported by actual importers, such as my business or retailers, that puts an added level of control on how it makes it to the end user, rather than end users being able to import the products themselves. And that's your question. Yes, I definitely do think that could be effective, because right now end users can import themselves. There's nothing special required in order to do so. And of course, if you limited it to businesses that are importing the product, that controls the supply chain a little bit more and makes sure that end users have to purchase their product through Canadian retailers that will practice these, safe practices at sale, and to ensure that they are educated and so forth.
Merci, Madame. Ms. McGregor, if you please, 6 minutes.
Thank you very much, Mr. Chair. I'm glad you brought up the issue of pellet guns, because I grew up with a pellet gun. I know a lot of my friends have pellet guns, and a lot of them do look like a real rifle from a distance. Of course, functionally, you can see the difference right away. But you said that the unintended consequences of how C-21 is currently written could potentially also impact the owners of pellet guns and their ability to sell or transfer what they have lawfully purchased. Can you expand a bit on that as well?
Yes, that would be correct. The way it's written is basically anything that looks like a gun, shoots a projectile, becomes prohibited under the way the law is written. So absolutely that affects more traditional pellet guns, or your Red Ryder BB gun. That kind of thing is absolutely affected. So we have to make sure we don't forget about that as well. Even though we're talking specifically about airsoft, that's still important to consider.
And you mentioned that about 90% of airsoft users use a device with an electric motor in it. Is that correct? Did I quote you correctly there?
Yes, that is pretty accurate for any rifle. I would say approximately 90% of the market is electrically powered.
And so roughly 10% they're the gas-powered options?
For the rifles, correct, yes.
And I've seen the internal workings of the electric ones. Certainly converting that to a fully functioning firearm would be, I think, pretty much impossible. But you're saying that it's most likely the ones with the gas-powered ones that could find a way with the technical know-how to convert that to something that could maybe fire a few rounds of real bullets.
Yes, and that is rare, but there are certain models, a lot of them come from Japan, where they don't really have real firearms, so they'll make things almost exact. But the RCMP does a good job at identifying these and then assigning FRT numbers if they've determined that there is a risk or if that they don't pose a risk. And like I said, this is primarily to gas models. As far as I'm aware, no electric rifle has ever been determined by the RCMP that poses a risk for convertibility. They are quite significantly different despite aesthetic appearances.
I think the struggle that our committee is having with C-21 is the way it's written is not giving us a lot of wiggle room on how to amend it to what the industry would like to see. Like, it's not easy for us to insert requirements for age, requirements for membership of a national organization, requirements to sign a waiver, because what C-21 is doing is basically amending the criminal code, changing the definition of what a replica firearm is, and deeming certain firearms to be prohibited devices. So, you're right, the concerns you have for your industry, because if you, after C-21, if it passed as written and you were the owner of one of these, suddenly, if you were to transfer it to another person, you could be charged with weapons trafficking. If you were to have a bunch of them, the police may say, well, you're possessing a bunch of them because you are going to traffic them. So I can understand the very real concerns that people have. And I'm just going to make a comment here. I think one of the options before our committee is we may just have to send the government back to the drawing board, because I don't think enough consultation was done, because we just have such a narrow laneway open to us to try and incorporate what the industry is asking for. And I do agree. I think a lot of them are very reasonable. Airsoft in Canada provided me with a briefing because they've taken some time to specify, their understanding of the bill and some of the options that they would like to see. You have a business. You've got quite a large stock of airsoft. Can you talk a little bit about how difficult would it be, given your stock of airsoft guns and the imports that you get, to make the changes to require that a certain percentage of the barrel is colored, or that I just could you rank them, how difficult it would be to make the major manufacturers comply with what you're proposing?
So for implementing a measure such as an orange tip, that is relatively easy to do. All manufacturers are already set up to do this because that is a requirement in the United States, and they are quite a large market for airsoft along with Europe. So even if you had to retroactively go back and make current inventory comply to having an orange tip, that is pretty easy to do. I don't really see that as being a very large burden. It would just be a matter of ordering the tips in, swapping out what you have for your current inventory, and then you would be in compliance. Adopting more of a two-tier model like they use in the UK would allow us to continue using current inventory, and then also now adding new products that are brightly colored for that lower tier of people who aren't engaged in airsoft. And then our other measures that we've proposed don't really have anything so much to do with the physical inventory itself, unless maybe we decide to have extra warning. A lot of brands already do have warning labels in the manuals and on the boxes, but that's not standardized amongst manufacturers. So that's also easy to do. If we had a standard warning label, you can put it on the box, put it in the manuals, and that's pretty easy to accomplish.
Thank you for that. That about takes my time, Mr. Chair.
Thank you, Mr. McGregor. So we'll start our second round of questions. This will be a shortened round again. So we will start with, who do we start with? With Mr. Mott, please. 5 minutes, please.
Thank you, Chair, and thank you for the witnesses for being here. Is the sport of airsoft inherently dangerous at all?
I would say no. In all the years that I've owned a playing facility, I've seen a broken ankle and a broken wrist. That was from tripping over logs running around in the forest. It is a non-contact sport. A lot of protective equipment is mandatory. It is definitely very safe. I would imagine you'd see more injuries in a contact sport like football, for example.
And you would agree with that, Mr. Hackenbruch?
Yes, sir. All injuries I've ever seen are related to, as Matt has pointed out, running around. No more dangerous than running or jogging or hiking.
I mean, it strikes me as odd. How many Canadians do you think are involved in airsoft in Canada? Do we have any numbers offhand in the sport?
I would say that would be in the hundreds of thousands. The Airsoft Canada Forum, which is one of the most popular forums that players join to talk about airsoft and that kind of thing, I believe currently has 380,000 members right now. And of course, there's a lot of people who aren't necessarily on that forum who do participate in airsoft as well. So it is quite a large community for sure.
So I'll ask you, Mr. Hackenbruch, does the inclusion of airsoft in C21 seem to be more ideological driven than public safety driven?
I can't really speak to what's in the minds of the people drafting the bill. I just know the way we read it, sections 1 and 2 would eliminate it.
Okay, so are you aware of any evidence to suggest that those who are involved in the airsoft sport have a greater propensity to violence or criminality at all?
Oh, no, sir. There's a great number of members who are part of the law enforcement community or military members. We're husbands and fathers, and, we're just, it's just our hobby on the weekend. It's our sport.
Yes, I would agree with that.
Okay. One of the challenges that many Canadians have with C21 is that it seems to target law-abiding citizens, those who have never been, and stats confirm that are not the problem with the gun violence we're seeing in our country. It doesn't focus on the acts of smuggled firearms used by criminals. So as you look at this piece of legislation, what recommendations excuse me, would you make to ensure that the legislation is focused in the right direction, not just forgetting your industry and airsoft, because neither one of you, but how can we ensure that this firearm legislation actually makes a difference for public safety and actually focuses on those that commit crimes with firearms, criminals? How do we do that?
I think primarily the conversation around airsoft tends to be misuse of the devices. So the solutions we've proposed would eliminate that in large part by restricting it to older individuals who are not going to abuse them, transportation, et cetera, et cetera. As to criminals, I mean, the laws already exist to prosecute people who misuse these devices. So that in and of itself could be a hindrance and a deterrent.
I just have one last question in the minute and a half or so I've left, but as I understand it, an unamended Bill C-21, and I think Mr. My NDP colleague creates a dangerous legal precedent and some ambiguity around the possession of airsoft firearms, which really they're not really firearms to the extent of it, but which would cause a really chilling effect on the industry and a real minefield, if you will, for those who are in this sport. So it's been stated by public safety officials and legislators that Bill C-21 airsoft people don't have to worry. Those who continually use these, it's fine. And yet the new classifications, as we know, prohibits these devices. So it sends some mixed messages. Where do you see we go from this?
That is definitely problematic. I think the only way to really go from this is to, if we're going to add more regulation for airsoft, we have to come at it with a more comprehensive package that acknowledges what airsoft is, and then we go from there to implicate some of the regulations that we've proposed, make it a little more specific.
Sorry, Mr. Mott. We're done. Thank you. We'll go now to Mr. Van Bynen. 5 minutes, please.
Thank you, Mr. Chair. I'd like to come back to the notion that the consideration that this committee is undertaking is much more than airsoft. It's about safety, gun safety, etc. And the crossover point at this moment for this discussion is likely the type of risks that the airsoft weapons present to our community. And I'm going to go back to the testimony of Chief Evan Bray, the Chief of Police in Regina, and he stated the following. When a gun that looks exactly like a Glock, which is a gun that we carry in the Regina Police Force, is brought out and used in the commission of an offense, most of the time, even police officers in the heat of the moment can't determine whether that firearm is real or not, and it does pose an absolute threat. So I'd like to come back to how do we differentiate if the airsoft weapons or if the airsoft equipment, I don't know how you wish to classify it, represents a risk. Why is there a reluctance to make them not look like a weapon that creates a risk when it is in a confrontation? Why is there that reluctance, that resistance? Go ahead, Mr. Roslike.
So I'm not really sure what you're proposing here, but if we're talking about making, let's say, airsoft guns look nothing like a real firearm, I'm not really sure how you accomplish that, because there's the saying of form follows function. So if you're trying to design a device that can shoot a BB, you need to be able to hold it, you need to have a trigger to operate it. It doesn't really matter at the end of the day. It's going to end up looking like a firearm, especially at a distance. That says there's real firearms actually that look more like space guns that are used in movies all the time. So you kind of get kind of a blurred line there of what something is supposed to look like in order to not look like a firearm, especially at a distance. So that's why we believe our proposals that are focused more on education and stopping honest mistakes are probably the most effective. When it comes to a criminal that is trying to use something while committing a crime, I mean, they're making that choice to commit a crime, so the police have to respond in turn to that.
You mentioned a two-stage system in the UK. Can you explain that to me, please?
Yeah, so more of the way that that system works is that it ensures that traditional airsoft guns are only available to those who are active in the community, who have gone through education so they know what they are supposed to do with them, how to, safely own them. Mm-hmm. And it ensures that people who have not gone through that far, so for instance, the casual user who wants to just walk into a store and buy something to plink around in the back of their farm, those people are limited to only buying a product that is very brightly colored to make it very evident that it is not a real firearm.
And could that not be applied to all weapons? Would that create a problem?
To have them all be brightly colored? Well, that definitely poses a bit of a problem for players in airsoft because, well, first, I don't think they're the ones anyways that are going to be, walking down the street in public with them. They know the rules and they're engaged in the sport. Also, too, when playing a game like that in a field, having something that is bright pink is not exactly conducive to, trying to hide and that sort of thing.
Could become cool, maybe.
Yeah. And, yeah, so I would say that's probably the reason. So that's why we think that two-tiered approach is probably the most effective as a good compromise.
I'm trying to find ways to eliminate the risk that people see that these weapons present outside of your theater, I guess. There were a number of items that I think you agreed on together with Scott. And there were some that you didn't. An example is that you mentioned that you would support safe transportation and safe storage regulations.
Oh, absolutely.
Yeah, okay. And is that held throughout the industry? So my concern here is, if you wish to be self-regulated, how could we ensure that everybody's interpretation of what is acceptable for safe storage, maintenance, and transportation of the unit, how could that be accomplished without it being regulated nationally?
So that's where we want to be able to adopt a standardized waiver, if you will, that has to be signed at point of sale by users, and that is standardized across the industry. So everyone is made aware of at point of sale what they are required to do to own such a device. And being standardized, everyone's working off of the the same framework there.
Mm-hmm. What are your thoughts around individuals being required to be licensed to purchase an airsoft gun?
So it depends on how far you're talking when it comes to a license. If you're talking to a full PAL, I do think that might be a little bit overkill for a BB gun. For licensing, what I do think would be more appropriate would be something like the two-tier model that's used in the UK, where you're educating and vetting that person ahead of time before they purchase by them joining the association and having to more or less complete like a test that they know the rules of what they're supposed to do. So if that would be considered a form of licensing where you get like an airsoft license after that so you can purchase normal airsoft equipment, I think that is probably more in tune with...
Thank you. I'm going to have to cut you off there. Thank you, Mr. Van Bynen. Madame Michaud, c'est à vous maintenant. 2 minutes.
Ms. Michaud, 2.5 minutes, please. Thank you, Mr. Chair. I'd like to come back to what my colleague Van Bynen was talking about on the association, the police association, which suggested that about making airsoft guns prohibited because they're too similar to real firearms. And this police association, I don't know if it's that one in particular, but we had been told a story about a person who was arrested or questioned by the police because they seemed to have a firearm, but in fact it was a camera on a tripod. And the Quebec Airsoft Federation said that perhaps there's a gray zone in C21 because the airsofts have been targeted. But the while there's other guns like the ones used to declare a race started, for example. There's those. Now, is it your opinion that there might be some gray zone around there, and that it was really intentional to target the airsoft industry?
I'm not sure I can comment that the bill was intended to target the airsoft industry in particular. That's I really don't have any way of knowing that. There definitely is a lot of gray zone as far as what looks, to look exactly like a real firearm. That it's very difficult to draw a line there, especially because things advance over time, looks change, styles change, so that's definitely difficult to do. I'm not really sure what else to say on that.
Peut-être Monsieur Hackenbrock.
Mr. Hackenberg, would you have something to add to that?
Yes, I mean, I would say that the example you've given of a camera being mistaken, at range, anything in a dark alley, whatever, it could be mistaken for an airsoft pistol or rifle or whatever. What I will say is that the Criminal Code of Canada right now clearly states that if you are misusing an airsoft pistol, you'll be charged as though it were a real firearm. So I think that cases where that happens and someone is prosecuted accordingly would go a long ways towards being a deterrent, and on our end in the community, educating people about what these devices will be treated like in the public is a huge part of a solution.
Merci, Madame.
Thank you, ma'am.
To Mr. McGregor, 2.5 minutes, please.
Thank you very much, Mr. Chair. Yeah, I mean, on that last point, exactly. Like, if you were to use an airsoft gun in the commission of a robbery, it would be treated as an armed robbery because the person being robbed has really no idea in the heat of the moment as to whether it's a real firearm. And if you are going to be using an airsoft gun in the commission of an offense, I think any reasonable person would expect the police to respond as if it was a real firearm. I think the problematic things are when we see like teenage children accidentally bringing something to school, and they may not know better, right? We know children, they don't always think ahead, and so I think the idea of putting in that age requirement at strongly educating responsible adults on how they need to keep their guns secure from young children so that they're not accidentally bringing it out in public, and having the police respond to what was an accidental incident, but which they have to treat very seriously. I guess, Mr. Hackenbrook, I'd like to turn to you. Like you mentioned that your association was created to work with government and law enforcement. You've heard the testimony that we've received from law enforcement on their concerns. I guess, can you just talk about, like, in your conversations with law enforcement, how have they received some of your proposals? Can you maybe inform us on a little bit of your work on that respect?
Many of the individuals we've spoken with, they're amiable to a number of our suggestions. I know that here in British Columbia, we have some provincial-based legislation that is going a long way towards restricting the age at which these sorts of things can be sold and participants can engage in the sport. So there is some work being done. It's a big conversation, though, and there's still a lot of other people that we need to speak with and sort of get what their understandings of how the industry works, how it's perceived, and also to really just get our side of things out there more.
Thank you. Thank you to both of you.
Thank you, Mr. McGregor. So that wraps up our questions for this panel, and I thank all the witnesses, both witnesses, for being here today. I thank you for sharing with us your time, your experience, your expertise, and helping us with our inquiries. With that, I would welcome the witnesses to leave if you wish. The committee has a couple of things to talk about, and if the committee members will stick around. So the matter before us, of course, is that at this time we have as an option to sit on Wednesday evening. Thursday evening. I stand corrected. That came about because I was trying to make sure that we didn't lose time on this bill while we accommodated the meeting with the minister and the commissioner. So when I thought they were available to us this coming Wednesday in the morning, I was looking for another meeting slot in order to do the C-21. And that was as of last Thursday. That's what I believed. And we nailed down that meeting on Thursday night. We've got witnesses lined up. We've got the clerk had to go through whatever gyrations in administration to get it done. So it's there. It's available. It's locked down. When I discovered that the minister was not going to be available on Thursday morning, or the commissioner, I kept it so that we would have options. For example, perhaps the minister would have been available for this meeting. But when I did find out that the minister was available on Monday, and we heard through the grapevine that Agri was not going to be using their meeting slot, we were able to nail that down. There you go. Thanks, Mr. McGregor. So that's how it came to this situation. So it's not cast in stone. It's an option. It seems to me a waste if we throw that away. We do have an opportunity. The witnesses are all lined up to go forward with it, but it's really a decision for the committee to make. So, Mr. Shipley, if you have a comment.
Yeah. Well, I gave you great praise last week about fitting in meetings. You're going above and beyond now, fitting in meetings. So, good work, I think. I have to, in full disclosure, I have a funeral Friday morning that I have to be back home for, so I will be traveling Thursday night. I'd have to find a replacement on Thursday night. That may not be the easiest. So, I mean, I've sat in for the rest of the C-21s. I'd like to be here. That's unfortunate, obviously, and I can't change those plans. So, I'll take the will of the room and see what happens. But unfortunately, I would not be able to attend myself personally Thursday night.
I understand, and consolations, of course. So. Thursday night is a terrible time for a meeting. I hate it. The only thing worse is a Friday meeting, and the only thing worse than that is a constituency week meeting. For people like myself and for Mr. McGregor, of course, who are trying to get to the West Coast, it's really nasty. So I understand that, but I'm certainly willing to, put up with that because I'd like to get this work done so we can move on to other things as well. Ms. Stancho, please.
Thank you very much, Mr. Chair. A couple things, but my understanding when we were attempting to schedule an additional meeting for our meeting yesterday, the point was made by certain members of the committee that the interpreters are having a difficult time in scheduling, and there was a lot of comments made about the additional strain we would be putting on interpreters to have an additional meeting in addition to the two we already have. So I'm just wondering if that issue has been resolved and our interpreters are no longer dealing with health consequences in the last few days that point has since been made. Is that no longer a concern?
Well, we're not adding to the overall workload of the interpreters because, for example, for yesterday, Agri Committee was scheduled for them, but they weren't going to. They had that slot, but they weren't going to do that, right? I'm sorry?
4 meetings for us in 1 week is completely fine for the interpreters, rather than 2.
Yes, I mean, that's one of the things, of course, when we try to get an extra meeting slot, our poor clerk has to work overtime to try and organize that. It's got to go through channels, and it's got to get the interpreters on board and everybody else. So that's where we're coming from. We've got it all laid down, all nailed down, and if it's the will of the committee to not meet on Thursday, we don't have to, but I certainly would encourage us to do so.
My second concern is that I do feel a bit that the goodwill that we've put forward in the motion, we put forward, I think it's fair to say, and I think that's acceptable, that we put forward a motion to have options if the meeting yesterday were to take away from C-21. But I feel that that's been taken advantage of, that goodwill, Mr. Chair, and that the goodwill we put forward to work together on that has been now maneuvered, that there's a new meeting, and that's not what the work plan is that we agreed to. We agreed to, as a committee, a very specific work plan. We're preparing our amendments. We have members of our committee who are flying home for funerals, others who are flying home to be with their families. I'm just quite concerned that the goodwill we've established now seems to be not a consideration in this regard. And the first that I'd heard about that was yesterday, but it sounds like this has been worked on since Friday. So I'm not sure why, as the vice chair, I was not informed of this until I heard it from a staff member. I didn't hear it from you. I didn't hear from the clerk. So I'm just a bit disappointed in the process of this, given that this committee has worked very hard for a whole year to come together on issues that I would say normally we don't agree on, and yet we found a way to work together. So I'm just concerned that perhaps there's a new tone that we're setting doing this, and I'm concerned about what that means with us working together moving forward. So perhaps you can explain to us why it is we weren't informed of this, why I wasn't informed of this until late yesterday.
Well, I certainly appreciate the goodwill that the committee has developed amongst all parties. But as I mentioned, the whole reason behind the Thursday evening meeting was because of the motion of trying to fit in the minister. It arose at a time when I thought we were going to have the minister on Thursday morning. In order to keep it, keep our schedule, I was able to find another meeting slot that was available. And our clerk was able to get that approved through all of the administration process, as well as get all the whips on board with it. And as I said, it's not cast in stone. So when the opportunity came for the minister to come tomorrow, the minister and the commissioner, yesterday, and we were able to secure a slot from another committee. It certainly became an extra meeting that we didn't necessarily need to have, but it's all set up, ready to go, if we want to take it. So I certainly appreciate the goodwill. I don't want to do anything to thwart that, but it kind of arose because of trying to fit in everything, and since it's there. I guess that's my argument. It's there, it's set up. We don't have to take it, but it's an option for us to do so if we wish.
May I just ask a final question? When were the witnesses invited? Because they've already been invited, have they not? When did those invites go out?
Well, those invitations started to go out last Thursday, when, as I mentioned to Mr. Mott last Thursday and Mr. McGregor, we were expecting to meet this coming Thursday evening because of the ministers. So they started, the clerk started to try to set that up, because they need certain lead time to do that. So he started setting it up then.
To be fair, as of last Thursday, there was this plan to have a C21 meeting Thursday night.
It was at that point still tentative, because we weren't absolutely sure that we were going to be able to lock it down. We weren't absolutely sure what was going to go on with the minister or the commissioner. Okay. So it was tentative. I mentioned it to Mr. Mott and Mr. McGregor on Thursday.
Okay. Mr. Chair, I just asked that you have those conversations with me as well in the future so I can be in the loop.
Absolutely.
Thank you.
Mr. Mott, please.
Thank you. A couple things. First of all, could the clerk read the motion from last meeting where we actually made the decision to have an extra one, please? Because I think that will clarify a lot of misunderstanding.
I don't think there's any misunderstanding. I know that the motion allowed for the creation of
meeting, and we had an extra meeting on Monday,
correct,
which is exactly.
But it doesn't preclude us deciding as a committee to go forward with yet another meeting.
The other thing is, like Mr. Shipley, I'm involved in the Special Joint Committee on the Declaration of the Emergencies Act. Mm-hmm. That happens on Thursday night as well, as Ms. Bendayan is. And so I too wish to participate in the C21 study, and I will be at the Emergencies Act meeting, so okay. I won't be here that night.
I understand. But as I said, it is a matter for the committee to decide today whether we don't go into that. Madame Michaud.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I too, I understand that it was your goodwill to, settle a date. But we received the Commissioner and Minister Blair Monday, so I thought that we didn't want to set back C21 so we could continue onwards this week. And now it does bring the date closer for tabling amendments. I don't know how the other parties feel, but from our end, we're not quite ready yet. There's a whole process, as you know, the whole legislative process to make sure everything is receivable. So I understand you want to accelerate the study, but if I look at the last timeline that was proposed to us by the clerk, there's still a lot of dates in December. Well, it's to be decided still. But if we want to finish C21 before the holidays, I don't think there's any reason to fear that because there's still time slots available. So I was wondering, why did we all agree in good faith? And I realized that there was a motion, but why did we change that idea without having really been consulted? So my concern has to do with the tabling of amendments. At which date does that bring us to when we do Thursday night? It would no longer be November 17th, if I understand correctly?
Also proposing that we bring amendments forward because we will have more time. But that's not, I'm hoping, see, we actually have to abandon this room shortly. So I see Mr. Lloyd wants to speak, I think Mr. Moff. I'm hoping that we can discuss the matter of a deadline for amendments maybe on Thursday, Thursday morning, depending on whether we decide on the evening. I'm wondering if because we are getting rushed for time here, whether we can have a quick vote on whether to go ahead with the motion or with the meeting on Thursday evening. Would that be acceptable to you, Mr. Lloyd? Or do you need to speak?
I just want to say one thing quickly. Is that, we talk a big game about trying to make a work-life balance in this place and, trying to help families. I've got a 2-month-old. I'm not trying to do an appeal to pity here, but, having a additional meeting on a Thursday night booked a very short notice does a considerable disruption to my life, to my family. And, I have been at every single meeting that we have had on C21, and I've been very involved in this process. And I just feel that it's somewhat like I understand what you've done, Chair, and like trying to find an additional meeting because there was the possibility that the minister would take up our Thursday morning meeting. And I respect that. Not trying to derail C21's timeline in any way. But to have an additional meeting on Thursday to accelerate this, is not something that I gave my consent to, and frankly is disrespecting my work-life balance. And I understand if members of the committee want to have a vote on this and want to do that, but we talk a big game about having a work-life balance as family, and if we're going to vote to just override that for some members because some people want to accelerate this, then I guess those are just empty words. But that's all I've got to say about that. Thank you.
Well, the point isn't necessarily to accelerate it. It's the fact that we do have this meeting slot that came available to us through this whole process I described. I personally don't want to waste it. It potentially would accelerate the study a little bit, give us more time to do amendments in any case. So I believe Ms. DeMoff would like to speak, and I would really like to get to a vote on this if we could. Did you wish to speak? Go ahead.
Well, I know we're short on resources, so we can just vote if you prefer, Chair.
Juste avant de voter, Monsieur le Président, si je peux...
Just before voting, Mr. Chair, if I may, if I could get an answer to my question, that would help me in my vote, because does that take away 1 week from our date? Does that take us 1 week less for our tabling of amendments?
It doesn't have to. The current date for amendments was a week later than that, but it would allow us as a committee to decide if we're able to get our amendments sooner, to accelerate that as well. But this decision is simply whether or not we have the meeting on Thursday, and whether we do the amendments sooner or later is a whole other question. Mr. McGregor.
So, we're starting to see patterns in the testimony, right? 3 big areas of contention: airsoft, the red flag laws, and witnesses being on both sides of the handgun freeze. I think we're very aware of, what the possible amendments to this bill will be, and I don't know if we're going to hear anything different. I'm speaking as someone who's a member of 3 committees. I'm okay meeting on Thursday night. I know that may not make some of my colleagues happy. I already had Thursday blocked off anyways. I'm one of those lucky people that has committee on Friday morning, so I'm not getting out of here until Friday evening anyways. So I would be okay with finishing up witness testimony this week. However, I do think Ms. Michaud's point about the amendments and the date those should be received by does bear some serious consideration by this committee.
I would certainly agree, and I want to emphasize that this decision does not necessarily affect that decision. So, go ahead.
So I will say something. Just on, I think we should just decide if we want to meet Thursday night. In terms of amendments, I agree with Alistair in terms of we kind of already know where we're going, but I don't think we should necessarily move up the date for amendments because we don't know whether the legislative clerk is going to have them ready in time. We as a committee decided on dates for the amendments, so I think we should have that conversation amongst ourselves to decide that. But I think if the time is booked, I personally wouldn't mind finishing the witness testimony before the break week, and then we can work over the break week on amendments, and we can have that conversation even on Thursday. And if we want as a committee to move up the date for amendments, we can look at that. If we don't want to, we've already got a work plan. But I think we can decide today solely on whether we meet Thursday night or not.
I mean, I think we need I agree with Christine in the sense that I am concerned about moving up any amendment date. I think we agreed to that as a committee, and we have to have a commitment today that date stands. That changes a lot of our work. We have a number of amendments we'd like to bring forward, and while I agree that we've heard several areas of testimony that about amendments, I think that there's still more that we'd like to learn. So I am concerned a bit, and given what we feel is a very underhanded approach, Chair, that this was scheduled on Thursday for days without me being made aware as the lead on the official opposition, I feel that perhaps there'll be an underhanded approach with moving this date on the amendments. So again, this is what happens when we don't talk about this as we have for a year. And now it seems like we're changing the tone. So we are concerned about that, and now I feel that I need to approach everything that is said with skepticism. So it's quite disappointing, Mr. Chair, but we can vote on this and just move forward.
Fair enough, but as I've emphasized, this decision is only solely, strictly about whether we meet on Thursday. It's got nothing whatsoever to do with amendments. That's a matter to be taken up on another meeting. And Madame Michel.
Merci. Je comprends ce que vous...
Thank you. I understand what you're saying, but at the same time, I get the impression that we're trying to rush hearing of the witnesses before the break week so that we can start our section by section study. But if that's the case, then our amendments have to be ready. So that was my understanding as to why we needed an additional meeting this week. If we're still hearing from witnesses after the break week, then it leaves us a little more time for amendments. That was my understanding of the calendar, but maybe I'm mistaken.
Previous work plan gave us. We finished up our witness testimony, I think, on a Tuesday. We had a deadline for the Friday. That's 3 days. That doesn't necessarily have to change by anything we're doing here tonight. All I'm asking is we have the meeting time set up. We have witnesses available. We can reschedule them. All I'm saying is we can have the meeting today or Thursday night or not. It's your decision. And that, that actually gives us all, if we stick to the regular amendment date that we formally discussed, that gives it gives us all an extra week to get that done. And that's something I think we need to take up later. We don't really have time. We've already kind of abused our schedule here a little bit. Can we just go to a vote on this now? And the vote is whether or not we stick with the meeting on Thursday night or not. So I'm going to ask everybody to raise their hands if they're in favor of that. And I see 1, 2, 3, 4. So people online, Mr. Varani and Mr. Dane, are you participating as well? Okay, so I see, and opposed to this, raise your hand. So we see 5 against and 6 for. So we're going to stick with the meeting on Thursday. I apologize for everybody who feels that this is inappropriate, but as you mentioned, as you saw, it came about because we're trying to accommodate the extra meetings for the minister and so forth. But we can deal with the amendments separately, and if need be, we have just that extra time to get appropriate amendments going forward. That being the case, there's being no further business. I thank the members, and we are now adjourned.
you.